My name is Pollyanna Deane. I'm a corporate insurance partner at Simmons Simmons. Today I'm going to talk about the top 5 ways in which governance can assist an insurer's conduct risk. Number 1, the risk management system. Solvency II requires an insurance firm to have a risk management system. This risk management system, which is dealt with in both the article of the delegated regulation and also the directive, requires the firm to have a risk management strategy which feeds into the business decisions of the firm. It requires the business strategy to reflect the material risks that the firm faces and also what the appetite is for dealing with those risks. Constant monitoring and reporting is required. It's essential under Solvency II that the board takes full responsibility and owns the risk management strategy. It will use that to make all its decisions. Number 2, culture. The culture of a firm is something that the regulators are very keen on. One of the key points to note is that the system of governance guidelines require culture and good behaviour to go hand in hand. Essentially, the Solvency II relies on the integrity of an insurer to manage behaviour and thus feeds into conduct risk. Frankly, the regulators have neither the time nor the resources to police conduct, so it's up to the firms. The PRA in May 2015 made it clear that they saw that culture, good culture and ethical awareness were crucial and expected the board to manage and monitor this. Number 3, the board. The role of the board is increasingly, whether for a Solvency II firm or any other, most important. The board is becoming increasingly held accountable, and it's clear from the PRA's consultation paper on board behaviour that they expect the board of any insurer to hold the executive to account. Under Solvency II, the board is expected to have the requisite skills, experience, expertise and qualifications in order to provide sufficient oversight and control of the insurance company. It doesn't mean that every single member of the board has to be fully aware of what's going on, but they need to have sufficient knowledge of what should be happening and also sufficiently good communication lines to ensure that they have the right information to make the decisions. Solvency II tries to ensure that there's little danger of a siloed information system. And we also see increasingly across the board training and qualification requirements being imposed. The board is therefore in the spotlight. And it is the thing that keeps the board awake at night, conduct risk. Conduct risk is going to be set by the tone from the top. And Solvency II makes sure that not just the board has to comply with conduct risk requirements, but the behaviours are flowed through the organisation down to the bottom. It is notable that internal audit, for example, is expected to continuously monitor this. Whereas corporate governance guidelines for non-Solvency II firms can expect to see regular updates and loopbacks from internal audit and other checks and balances, the Solvency II firm is expected to do this more regularly. It's probably going to be at least quarterly. And for example, if either compliance or internal audit have decided to highlight a point, they will expect the board to follow up on it within a reasonable time. Number 4, documenting compliance. We've always heard the regulatory mantra, do it and document it. Solvency II makes this more important than ever. Under Article 266 of the delegated regulation, firms are expected to have an internal control system, which means that they need to evidence compliance with regulatory requirements and the administrative provisions of Solvency II. Do it and document it has never been so important. But one thing to bear in mind here is that internal control doesn't suggest there's a different system. It just suggests a different approach. And something I think which is really important is that it's not just do it and document it, it's document it and do it. Solvency II contains considerable numbers of policies. You may have a written policy, but if you don't follow it, you're not going to be much use as a Solvency II compliant firm. So while I would appreciate if you all did it and documented it, I would really appreciate if you then followed the policies by documenting them and doing them. Number 5, outsourcing. Now this is an interesting one because I don't think it's really the best way of managing your conduct risk. However, a number of people have come to me and said, could we please outsource our conduct risk to you? The answer is no, it's yours. However, one of the key things to remember is that outsourcing is something widely used in the insurance industry, and Solvency II firms are extremely familiar with it. It is as a result of this that Solvency II highlighted that outsourcing was a major risk, and there are considerable numbers of sections of the directive, Article 274 of the delegated regulation, which talk about the requirements for outsourcing. Indeed, if you haven't started looking at your third-party agreements, you should be doing so now in order to ensure that they comply with the terms of the directive. It should be said that delegating your conduct risk is probably going to earn you a black mark from the regulator. On the other hand, if you use delegations and outsourcing wisely, it may well enhance it. Thank you for listening. I hope you found something interesting here. For more information, go to riskmindslive.com.